Caitlin Jackson from Williams-Kastner up in Seattle. Caitlin has been very active for the last few years that I've paid attention to regarding landlord tenant law and general real estate law. I want to take a quick second and let Katie do a quick introduction of yourself and explain how you ended up where you are, what made you decide on real estate law in your area of practice, and how you got where you are.
Thanks. Yeah, my name is Caitlin. I often go by Katie. I answer to both. Jackson is my last name. I'm an attorney. I'm currently at Williams-Kastner and Gibbs, which I think has been around in the Seattle area. We have offices in Seattle and Portland, and I do think they are expanding or have expanded into Spokane as well. But it's been around for about 100 years. It's an old firm. My office, I'm right now on 2 Union Square on the 41st floor. I practice generally real estate law, but more specifically, a lot of landlord tenant law in the state of Washington. I did not intend to be a landlord tenant attorney when I started practicing. I fell backwards into it. And with the timing of me entering the field of real estate law and the pandemic happening relatively shortly thereafter, and all the laws changing in landlord tenant law, I think spurred by the pandemic and have continued to spin out of control since then, I've just been sucked into it. It is now a practice that you either do it and you pretty much do it full time, or you shouldn't touch it at all because things happen and change significantly and very quickly. So staying up to date on all the details is absolutely critical, at least as an attorney. So that's how I got where I'm at. And that's where I foresee myself for the foreseeable future.
And so what year did you start landlord tenant stuff?
2018.
Okay.
So literally 2 years before the pandemic. Yeah. So it's been 5 years of craziness, 5.5 years. Yeah.
Yeah. And I've talked to several offices, and one of the things that is very consistent with what you're saying is generally now with all the changes, they recommend a younger attorney that didn't have all the background of the old ways, like the Old Testament, if you will, of like how things used to be. And so the younger, fresher attorneys that maybe haven't been practicing as long maybe can be a little more fluid with the changes. I don't know. That was a perspective. I was like, oh, it kind of makes sense in some ways. And
I can understand it. I may not agree with it. I think some of the attorneys that have been practicing this for a very long time are very good because the history and the case law history can add benefit to it. But I think what it comes down to is whether or not that attorney has been solely practicing or mostly practicing landlord tenant law. I don't think it has to do with how many years they've been doing it. It's how engaged and how involved and how much of their practice area is dedicated to it. If they're an attorney that practices general business litigation 60% of the time and estate planning 20% of the time, and then landlord tenant 20% of the time, that's probably the biggest indicator that if you're looking for an attorney to put your foot on the brakes and discuss it very carefully with that attorney, just to make sure that they've stayed up to date with the current changes. And a lot of that could have to do with the city or the county that the property issue, if there is a property issue, is located in. There are a lot of counties where things are much more simple than King County. There are 39 counties in the state of Washington, I want to say. It might be 35. I actually have to look it up. I'd say there's only 6 counties that are really challenging. A lot of the other counties have tried to keep things simple. So it really just depends.
Which counties do you specifically practice in, and what's the list of the 6 challenging counties?
So I think it would be Thurston. So first of all, I generally practice King County. I do have cases in Snohomish and cases in Pierce, and I stay on top of those areas very carefully. But I would say maybe it's just because of density and my personal location that King County is my primary area of focus. The 6 counties are, I would say, King, Snohomish, Pierce, Thurston, Spokane County, and probably whatever county Bellingham is in. Is that
What
Whatcom?
county is that? It's not
It's up north. Yeah, way up north.
like
Wherever Bellingham is, because Bellingham is it's a very like liberal town or area in a small footprint, but then around a lot of rural areas. That one's kind of an interesting one. That one's kind of funny. But yeah, those are the counties that I think are the most challenging in the state right now.
Yeah, I thought things were nuts here, just the Washington stuff. And then you start hearing like more and more things they add, just the extra little kickers. It's each one's like every time someone comes up with something that makes it crazy, then another county, hold my beer, I got something else for you.
My beer. Yeah.
And it's like Washington and Oregon do the same thing. I was just down in Oregon, and a friend down there who's an attorney is telling me that even if you're after your lease, and they started the just cause stuff, but after your 1 year lease is up, you give them like the 90-day notice that you're going to be ending the tenancy, and you also have to give them a month's rent at that time too. Like when you give them the notice, like here's a couple grand also. I'm like, there you go. And I was like, no, that can't be. And it's like, yeah, no, that is. And so I think I've heard that, and I don't know which counties because they're not in any of the counties or cities that I'm in, but are there some up here that kind of do something like that or start requiring you to pay moving costs for tenants and that kind of deal?
It's called relocation assistance.
Okay.
And there are some requirements in some areas that require relocation assistance, but it's not the same as far as I know, comparatively speaking to what you're talking about. It's if you're ending the tenancy for a specific reason, like you're going to do some significant rehabilitation to the property, or the property has become uninhabitable for some reason, then there are certain areas and certain state laws that require relocation assistance. Yeah, I won't get into specifics because trust me, you don't want me to. But there are some scenarios in the state of Washington, not just statewide, but also cities also. So Seattle has like a relocation assistance requirement. If a property, for example, if you're going to change the use of the property, I think you have to give 90 days notice and go through this permit process that can take much longer than 90 days. And you have to provide relocation assistance. And I think even if you raise rent over a certain dollar amount and the tenant has to vacate, they call it economic relocation assistance requirements in the city of Seattle. So if you raise rent, let's say 12%, and within X amount of period of time, the tenant decides they can't afford it and they leave, they can apply for economic relocation assistance, and the landlord may be required to actually pay that relocation assistance, the money.
Yeah. Okay.
The difference there is that I think that the city and the landlord actually pay part of it. It's like half, you split with the city the cost of the relocation. But I'd have to look it up and see if that's actually true about certain types of timelines or reasons and others.
Okay. At least that sounds somewhat more reasonable. I would assume that the big part of that is just because of all of a sudden now you want to put in an apartment complex and the zoning changes and it's going to be a big development and it's a big deal. And I could see if you were going to do that with a property, why it might make sense to compensate the tenant for moving, and you're going to improve the property, so you're going to do great on the deal. I don't love it, but I see that one a little bit.
And I think Seattle's in particular is tied to the financial circumstances of the tenant as well. I think they only qualify if they are of a certain income threshold. Okay. So it's not just for anybody. It's for tenants that probably are at most risk of having a scenario where they really struggle financially to fund relocating, which relocating can be really expensive. If I had to move out of my house, in 3 months, I had to locate a place that's within my budget, first month's, last month's security deposit, that can easily add up to $7,000 or $8,000 or more that you have to have up front. And some people would really struggle to do that. Most workers live paycheck to paycheck. That's a lot of money to come up with in that period of time. So as inconvenient it is to landlords in that respect, the place the policy comes from is a good one.
Yeah. So that also leads into, is it a statewide or just city specific that you're required to take payments for your deposit, your security deposit? That's a statewide thing?
Yeah.
So if they meet your minimum criteria or whatever, then you just have to take payments, and
if they request it, you have to agree to it.
Okay. Is there a breakdown of like how many months?
I think it's 3.
Okay.
Pretty sure it's 3.
And do they stop you from being able to get last month's rent, or is that? restriction too. So at least you get more upfront that way.
I think it depends on the city or the county if they've passed their own rules. But most cities, if they're in King County, they're following the rule that your move-in costs cannot exceed 1 month's rent. But I do think that I don't think last month's rent counts because they're paying rent. Like it is their rent. And I think move-in costs are different. I'd have to look at it because I have to look at things now through the lens of city by city. I don't say I ignore the state law. It's just now my first place that I go to is actually the city ordinances
I
rather
could
than the state
see
law.
that. I could definitely see
City
that.
ordinances are always more strict, almost always more strict than the state. So
That's way more efficient use of your time, I'm
yeah,
sure, that way.
yeah. And they're
Yeah.
all different.
So, as a landlord and having gone through the process of providing the required repayment plan and the 14-day notice and giving them notice for the ERP or DRC or whatever acronym,
ERP, Eviction Resolution Pilot Program. Yeah.
giving them all that, and then going through and I want the mediation, and then having to schedule that, and then you're like 6 weeks out, and I'm just like, okay, so if someone brand new moves into my property, they've only given me 1 month's rent, I can't take a deposit or anything because they requested a installment plan for their deposit, and then they skip on the next month's rent, and I'm into a 6 month long ordeal just to evict them, and I haven't even gotten a security deposit out of them, and I'm not allowed to if they want a payment plan.
Oh, that's happening all the time.
And I just, at some point, common sense just disappeared. And I want to go into.
Okay, I'll back you up. I'll back you up for a second because I hear that a lot. Like, where did common sense go? And I get it. Trust me, I am a landlord, so I understand this. And it has just become a much riskier business than it used to be. That's the reality. And when somebody says common sense, depending on whose perspective, right? The legislature and the city councils, and I would say the general public in the 6 counties that we're talking about, their common sense is housing first, right? Like their perspective and the lawmakers who put these policies or laws in place, they're not looking at it from the landlord's perspective. Common sense is people need to be housed. Otherwise, we have a lot of unhoused people and we have a homelessness problem. So their common sense is we need to get them into housing and we need to make it as affordable and easy for the person trying to achieve getting housed as possible. That's common sense to the lawmakers. It's not common sense to housing providers who rely on income in order to run their business. But if you're looking at it from that lens, it makes sense. Do I agree with it? I don't know. Probably not. I would say we have a lot of laws and policies that have an objective and they swing and they miss. But
unintended consequences was going to be
unintended consequences and a swing and a miss.
I'll just from my own perspective, I used to give people chances. Like I came from a world, I did bad credit auto loans for people with bankruptcies, repos, that kind of thing for 15 years. And a good story, a good reason. I'm going through your credit report. I see that, oh man, you weren't planning on your husband dying 5 years ago, and that's why all these bad things happened on your credit. You look like you've got a good job now and everything's going here. But yeah, you did file bankruptcy a couple of years ago and you went through the other issues. Maybe even had an eviction 5 years ago when that happened. And I would look for reasons to try to help people. And now there's zero reason to, and you get one bad person in there, and now you're 6 months or longer dealing with it, and they get a free attorney the whole time to dispute every little just frivolous thing they can to extend it and get another continuance. And I had to stop that mindset. And so I know other landlords are in the same boat.
Oh, me included. No, I like to tell people no good deed goes unpunished anymore. You can't. But that is not an unintended consequence. That's an intentional consequence. Trust me, the people who went to lobby to the state legislature on behalf of housing providers very much explained to the legislature that this is what would happen. And so it's on the record. This is what would happen. And they know that, and they knew that at the time, and they went forward. So at that point, it's not an unintended consequence, it's an intentional consequence. Housing has not gone down in cost. Housing has become more difficult to find, especially single family homes for families. And landlords or housing providers are less likely to charge under market rent or to take any chances on anyone that has any discrepancy on their rental history or financial status. Yeah, but those are intentional at this point because the legislature knows that's what's going to happen and what is happening. And that was the choice they made.
Yeah. Well, it was a 4-day, when it was day 4, you could do the 3-day pay or vacate and file an unlawful detainer. It was, and you could do a flat fee eviction with an attorney. That's unheard of now. That's gone. I think that's gone away.
Not unheard of. It's just what county are you in? If you're in Clark County, you can find a flat fee eviction, but
Okay.
certainly not in King. I don't know anybody in King doing it. I guess there's a couple, but I don't know how.
I know in Thurston, I haven't found it yet.
I am
Yeah.
not. To be very clear, I'm very expensive.
Yeah. And you don't have to share if you don't want to, but what's the average attorney or the average eviction running where you are for clients these days?
Well, it just depends on the reason why. So
Non-payment.
yeah, for non-payment, so there's a big chasm between non-payment and the landlord actually wants to keep the tenant, and non-payment and the landlord really wants the person out, because that changes things a little bit. A non-payment case where the landlord wants to keep the resident and is really hoping that they find rent assistance, those ones are actually relatively straightforward and are becoming a little bit more straightforward as long as you're keeping up with the local ordinances and the different notices and how big a font it has to have in it, that kind of stuff. As long as you're staying on top of those things, probably $2,500 is probably the average because they get reinstated. And a lot of times, a big chunk of that $2,500 is actually included by rent assistance. So the landlord in that scenario can get made almost whole, but the process is what takes so long. So the risk to the landlord there is you could get in through the entire process and maybe the tenant skips town before the hearing. And then you end up in a situation where it's taken you 4 months to get through the process and you're not going to be able to get rent assistance to pay for the rent that is due or the attorney's fees, and the tenant has skipped town. So even if you get a judgment, which you won't because because if they default and they don't show up to the hearing, you can't get a money judgment. All you can get is a writ. Well, you're out all that rent and the attorney's fees. So that's the biggest financial risk. And if rent is $2,000 a month, and let's say that process took 4 months, and that's on the conservative end, you're going to be out $10,000-$11,000 pretty quickly.
And then, yeah, what I found is when people don't pay for their housing, they don't take care of the housing either.
Correct.
And I'm flipping my own property right now that is, you don't, and you've probably paid attention, but like used to be, I could go and do a cash out refinance and okay, cool, I'll get my money back from the rehab and make it work. But now rates have gone so high, it doesn't make sense to do that. So now I'm gonna have to go through and do a 1031 and sell a property because I had a tenant trash it.
Yeah. Oh yeah. And that has been a real struggle for a lot of my clients as well.
What, you probably know the numbers more than me, but Seattle, I think last year or the year before, I saw a number that they had lost something like 10 or 12,000 single family rentals from landlords selling with a lot of the changes. Do you keep up, or do you remember seeing that?
I keep up peripherally because I actually know a little bit more. I know too much. I know how skewed these studies are. I know here's what I can tell you. It's probably more. I can tell you that between 2020 and 2022, I did more evictions, let's say even in the heart of the pandemic, right? When one of the few exceptions to the eviction moratoria, whether it was city or state or whatever, was selling the property. I did more evictions during COVID, during the heart of COVID than I ever did before that because people were just selling, especially single family homes were just like people were bailing out of the market left and right, which of course they were, because if you can't collect rent and you have a mortgage, you don't have a choice other than foreclosure. And as a matter of fact, there's a Protecting Tenants Against Foreclosure Act, which actually continues to protect the tenant even after the house has been foreclosed on. So I did an unreal amount of unlawful detainers during that time period. So I think that a lot of the numbers about how many, and I took statistics in college too. Like, I know how these things work. You can take a statistic and twist it 10 different ways. Doesn't matter. What I know is that my colleagues and I all agree we did so many evictions from 2020 to 2022 and continuing now because people are selling their single family homes. They cannot absorb the risk that exists as a landlord of a single family home. And I can tell you, I have clients whose tenants haven't paid in 2 years. They're damaging the property, and it takes forever and tons of legal fees to get them out because there's all sorts of ways that they can find to stay in as long as possible, whether it's file for bankruptcy or whatever. Yeah, it can be hundreds of thousands of dollars of damage. Hundreds.
Yeah, that hurts. You put together, walk me through the slides and the thing, like what's a brief description of kind of your, something about too many cooks in the kitchen or something along those lines. I walk me through that kind of, I'd love to go through that with you.
Yeah, so I did a presentation last week. I called it was for Washington realtors. I called it, this is not the same, but this is a similar one. But I called it Too Many Cooks Spoil the Soup. And I don't know why, but it was a book that I like read in second grade. I remember my second grade teacher, and I don't know why that stuck in my head, but I was like, this is actually really where we are now. Because what we have is the state law changing constantly. Every year there's changes. But then we don't have what's called statewide preemption for landlord tenant law, which is really where, if those that are interested in politics and in these laws really pushed for this, would make a huge difference for housing providers if we just had statewide preemption. Because if we were all just looking at the same set of laws, and those laws we knew were only going to be changed or potentially changed once a year and go through a very rigorous legislative process, things would be at least consistent across the state. Or at least we'd have those laws and the federal laws to deal with. But right now, the way we have it set up is there's no statewide preemption, and every city and county can do their own thing and add to that pretty much willy-nilly. It doesn't even take like much notice. Like a city council can be like 1 week's notice, 2 weeks notice. We're going to discuss these changes that we've talked about on a coffee break over the last 2 days, right? Like,
They hear one story, like one story
they
of
hear one story.
now the law is different.
Yeah, exactly. It's actually laughable. Like, I was watching Burien recently. Like, literally, they still put in changes without very much of a heads up to the community at all, and it really does impact people in a very significant way. Not just tenants, homeowners, but the cities can do whatever, not whatever they want, but they can wield an enormous, I guess is the word I'm gonna look for, an enormous amount of power over the rights of housing providers. And also you have the counties, which can really only deal with the unincorporated areas, but you have those as well. And then you have federal law like the CARES Act, and then you have Court of Appeals dealing with state law. All of these things you're having to deal with, all moving parts at the same time. Sometimes they're overlapping with each other. They come up with different definitions for things. And this is why I call it Too Many Cooks Spoil the Soup. It's gotten to the point where nobody knows what's going on because there's just too many cooks in the kitchen. And that even hurts tenants in some ways because they don't really know what to expect either. If you're living in the city of Burien and you're 2 blocks away, you move 2 blocks and now you're in the city of Seattle, your rights are significantly different. And sometimes that's good and sometimes that's not good. So that's where we're at with it right now. It's just all the changes. And I did a cool graph. It was on between slides 5 and 6. So slide 5, which you're looking at right now, these were the significant changes in landlord tenant law between 1973 and 2016. That's 40 years-ish. That's a lot. And there's the 1973 Landlord Tenant Act, RCW 5918. That was it. Then you went almost 10 years to the city of Seattle just cause evictions. That's not even state, that's just Seattle. Then in 1992, Seattle did restrictions on selling low income housing. Then in 1989, 7 years later, there was statewide deposit accounting. So you went between 1973 and 1989 statewide. There was these two changes. Everything after that, Seattle in 1990, there's tenant relocation. I think that's relocation assistance. In Seattle in 1993, which is 3 years later, tenant information packet. And Pasco in 97, registration inspection. So there's a lot of Seattle here between 1973 and 2016. But even then, there was just that activity every few years, there was one change. Now, if you move to slide 6, what was created, and this, by the way, this infographic was created by the Rental Housing Association of Washington. I'm using it for illustration purposes, but I would like to give absolute credit to them in making this clear and creating this. They've done a wonderful job, and they did allow me to use it, but I do need to give them credit. So then moving to slide 6, if you can move the next slide forward. I'm doing it. I'm doing it. Sorry. This is, did it work? Can you see it? Yeah. So I couldn't even fit, sorry. I couldn't even fit all of this on the screen.
Jesus.
Hold on one second. Okay. I'm going to see if I can move that. I couldn't even fit it all on the screen, how many changes have happened. The green being state, the blue being cities, and I couldn't fit it. I couldn't fit it in Rental Housing Association of Washington, couldn't fit it. It's not just changes with the state law, it's changing every year, but the city laws, Seattle had 5 changes in 2022, if not 2021. So they're changing multiple times a year. And it's not just Seattle. Now you've got all these other cities that are changing as well. And they're not just changing once, they're making multiple changes a year. I have been recently convinced, which I don't know if I agreed with this before, mines can be changed, mine included, that the best gift we have as Washingtonians is a part-time legislature.
Oh my God.
Because if the only tool you have is a hammer, everything's going to look like a nail. And if you're a full-time legislative electee, you're going to just create laws. Nobody goes through and says, you know what, this one doesn't work, we're going to get rid of it. They just like to create more. And that's where we're at. The next slide that I had was just the growing list of local rental regulations by city. So, and these are growing as well. And so these are all different cities, mostly on the west side. There's more. I know Spokane has passed things, but there's more going on in that direction as well. So you have to deal with Auburn if you live in Auburn, and then you got to deal with the state, and then you got to deal with the federal stuff, and then you got to deal with Court of Appeals. And even then, when you go to court, you're dealing with a commissioner that may or may not really understand or agree, and you might have to revise them through the judicial process. Like, it's a very cumbersome deal right now. I will say one of the most egregious cases I've seen recently was a 3-day notice to quit because the person did not have permission to live on the property. This was not my client, thankfully, not my case, but what had happened was the person had gone through a divorce, and their spouse was very angry that this person was awarded this particular property in the divorce. So the spouse had actually moved in a stranger into the house before the husband could take possession, and signed a rental agreement with that person. And the spouse did not have any legal authority to do that. They were, through the formal process, they had no legal rights to do that. And this property was in federal way. And so when the spouse went to the property to take possession and there was this stranger there, they basically were like, "Who are you?" And then the stranger just filed a protection order against them, to keep them away from the house. And then they learned the stranger's name through the protection order process. And then it was discovered what had happened, and the attorney for the real owner and person with the right to occupy served a 3-day notice to vacate because this person had no right to be there. And because the city of Federal Way has expanded their definition of tenant to be any person in possession of real property, the person's a tenant. So the landlord, the owner, even though they did not agree to be a landlord, did not want to engage in being a landlord, wanted to live in that property, intended to live in that property, the court awarded them that property to live in, had to go through a very long, arduous, and expensive eviction of this person. I don't even know if that's ever resolved. And they were living at, the home owner was actually forced to live in their car. It just shifted the homelessness from one person to the other, except for the person who actually owned and had the right to the property was the one that ended up being homeless.
I'm sure they were paying the rent as the lease stipulated too. And
No.
well, no, but that's the same thing. Like it doesn't even matter that it was the former owner of the house. In the lease, everything I've seen is you can just produce a lease that Mickey Mouse signed as the landlord. Like now you have to go through a whole new process that, like, no, it doesn't matter that it's invalid. It doesn't matter it's fraudulent. It doesn't matter anything. I have this lease.
It's going to be, you literally, they do the Google lease online. It's a Google lease.
Seriously.
They Googled it. They printed it out. They went onto the public website to see who the owner was, filled in the blank. It happens all the time. And it'll take 6 months and 10 grand at least to get them out. And not to mention the loss of use, which is part. Even if you get a judgment, you probably don't even know this person's real name.
Yeah,
You're not
even if they have a job, if someone's doing that and getting a fake lease,
yeah, normal people.
they're
Shouldn't have
super
collectible
collectible.
income.
They'll just garnish your panhandling.
Yeah, I mean, what's interesting is that, like, the whole point, I don't think people are generally aware that there are two processes, legal processes, for establishing the right to possessing a property and ownership. And there's the ejectment process, which is a full-on civil lawsuit with a case schedule in front of a judge. And then there's eviction through the unlawful detainer statute. The whole purpose of the unlawful detainer statute was to be fast and efficient because it was limited to the right of possession. And it's become so cumbersome and expensive that I don't think that the unlawful detainer statute serves its purpose of why it started at all anymore. I can finish ejectment actions faster than I can solve eviction cases through the unlawful detainer statute. The only benefit that I see of an eviction process over ejectment at this point is if there's certain facts, like it's a non-payment of rent case and the landlord does ultimately want to keep the tenant and get rent assistance for that tenant, then the unlawful detainer statute makes sense because that's the fastest way to manage that. Or if their landlord is concerned about counterclaims, then the unlawful detainer statute still makes sense because counterclaims are generally not allowed in unlawful detainer cases, but they are allowed in ejectment actions. So there's sometimes when one is more appropriate than the other, but the whole purpose of unlawful detainer was to be fast, was to be efficient, was to be swift. That doesn't exist anymore. It's not swift. Most ejectment cases are resolved in the same amount of time.
Yeah, I shifted. An attorney told me that basically it's faster now to foreclose as it is to evict. And I've shifted some of my properties that were rentals to selling on seller financing, so I can still get the cash flow out of it. And if they don't pay, at least my understanding is they don't get a free attorney to try to fight me the whole time and drag things out even more.
I have bad news for you.
Oh, no, don't tell me. Don't tell me that. Don't tell me. They get a free attorney for a foreclosure too?
In March of this year, Housing Justice Project filed their articles of incorporation to be a traditional nonprofit whose objective is to defend any person that is going to basically be evicted, which is not just unlawful detainer, but just removed from their housing. So they can appear in anything they want now.
Oh my God.
As long as they're dealing with somebody being removed from housing. It's not, I don't even think it's linked to income anymore. They don't have to be somebody that's 200% below the federal poverty level or anything like that. It's just anybody. Now they have to account for public funding. So this is our taxpayer dollars.
The next question.
Working against us. But so if they're dealing with an eviction through the unlawful detainer statute, that some of the funding that they have that is to represent those tenants would be limited to that person's income, et cetera. But now they can take funding from all these different grants and donations, and those ones may not have the same strings attached. So I have ejectment cases that are not landlord tenant cases, and they are appearing and defending just like a regular civil lawsuit. But that just happened in March of this year. So you can bet that anytime you're removing somebody from housing, you have the threat of the housing justice project potentially delaying your case significantly.
So and this is just a little bit of a tangent, but like in Section 8, we provide government funds for people that have low income, right? We give them assistance, we give them, but the person who's getting the housing still pays something. They still pay $200 on a $2,000 rent or whatever. They have some skin in the game, even if it's just a small amount based on income. How are we giving a blank check to this Injustice Project, which is such an ironic name, just to allow to continue to delay what's going to be inevitable in almost every case anyway, without any sort of buy-in, even if it was $20 or you maybe paid $10 an hour or $20 an hour based on income toward their legal fees, 90% of the stuff would go away because they know they have no basis or no grounds of some of the delays for like fighting a fee or fighting they didn't pay, like for non-payment, they didn't pay. They're going through the process, and if they don't agree to a repayment plan, they still are able to drag it out with continuances like for months.
Because their calculus is not money. Their calculus of success is how many, well, it can be money, but one of the elements is how long can I keep this person housed? Because remember, go back to the mindset of we have a housing shortage. We are like 3 million something units short. Maybe it's not 3 million. Maybe that's nationwide, or is that statewide? I can't remember. Anyways, we are a lot of units short of what we need in this state. And we do have a homelessness problem, and we have a housing affordability problem. So from the lens of keeping people housed who are at risk of homelessness, that their calculus is how long can I keep this person housed? That's their job. So it doesn't, I guess the question you're asking is, why don't we require the tenant to put any skin in the game? If you look at it from that lens, you could argue they have all the skin in the game because they may lose their housing. They might be homeless. And there's that's a very harsh result for failing to pay a fee or even rent. I disagree with that assessment in many ways because I don't very few of my cases are actually just based on a little bit of money. We're talking like one of my cases, they owe $100,000. Two of my cases, they owe $100,000 in rent. But I think that that's the lens that they're operating from. And if you put yourself in that place and things like through that lens, you can understand why they operate that way. I think the bigger question and the better question is, why isn't the government stepping up and creating that housing?
That was exactly, if you want to provide free housing, by all means, government.
I would love it. My issue is that this is private property. This is a private contract between two people over this person's property. I certainly think that the government shouldn't be writing blank checks to keep people housed where they're breaking contractual agreements over private property. That's been the way that I see it from a policy perspective is, by all means, I would love if our housing crisis was solved. I would love if our addiction crisis was solved. If we could solve behavioral issues by quick removal of tenants that can't comply with lease terms, as if the government had enough sufficient public housing for people to live in, that would be great. But the government is putting all of the responsibility and risk on the backs of private property owners right now.
I think it's utopian. Like from their lens, all of these people everybody's good people. Everyone who's a tenant is an amazing individual, and they intend to pay, and they intend to have gainful employment, and that the only person that could stop that is an evil capitalistic landlord who, and so
I don't think that they operate like that. I think they're smart. I do. I just think that it's unfortunately easier to put the burden on the private property owner than it is on the government, because the government is not going to do it. And as a matter of fact, it's more expensive it's 70% more expensive for the government to create housing and run it than it is for private property people, private investors and private owners to do it. So the government's perspective is, why would we do that? It's cheaper if we have it on the backs of private property owners. So it's an interesting shift and balance and constant weight. I think right now we've just hit an imbalance, and hopefully there will be a correction at some point. And I imagine that there will be, because this just cannot continue with the rules changing every week and it not helping. Like, no, none of the indicators have said this has worked.
Yeah.
As a matter of fact, the eviction resolution pilot program went back in front of the legislature this year to see if they wanted to renew it. And it was not renewed because it was clear it was a dismal failure.
Oh, I love when they sent me the survey email.
It was so cathartic, wasn't it?
I let them have it, and then they're like, "Do you mind if we use your thing on our material?" I'm like, "Yeah, please do." Yes, they'll check that box. Do that.
But people don't realize it wasn't the dispute resolution center's fault that it was a failure. It was the fact that the government tied the rent assistance funds to people who were at risk of eviction, and then they defined at risk of eviction for only those people who've had a lawsuit served on them. When you were in the front of the dispute resolution center, you couldn't get a lawsuit served, right? So because you didn't have your certificate, so they couldn't get rent assistance. So it was a self-fulfilling prophecy of failure. It was like, no, we actually need you to sue and bring an eviction action before we can get this person help, which was just sick.
How long is the certificate good for?
I don't know.
Okay.
Nobody knows. Nobody knows anything about that process. I have one case right now where the certificate was requested in May of 2022, and it wasn't even issued till December 1st of 2022. That's how long it took. I don't even know how you prosecute a case that long. It's nuts. I think it's safe to say it's good for 60 days once it's been issued.
Okay. And then, but your repayment plan is like 10 months on this one I just did. That's like, now our mediation agreement, we have a repayment plan and you can only do a third of the month and they're a lot behind. So we're talking 10 months of payments. So I would logic, but we don't live in a logical place, but logic would be like, okay, if this happens during the repayment plan and they miss their payment, I can go and use the certificate, but it's 8 months from now.
Yeah.
And that's,
it's a mess, but it's done after July of 2023. So I think a lot of people are just like, let's just keep chugging along until July and then we won't have to do it anymore.
Did you have any other slides you wanted to show?
No, and I actually have to go. I have another meeting at 10. So
okay, fair enough.
I would just tell people, do not try to do this yourself. Do not. Don't do it.
Nope. Nope. hard pass on that one.
And unfortunately, screen, and I'm sorry, but I'm not taking risks with anybody, any glitches.
So
no, I mean, it's still a good business to be in. It's just you have to understand the risk and you have to make business decisions about how to properly plan for that risk. And if you can do those things, it's still a great business to be in.
Your chart with all the changes shows me that you can't plan for the risk.
That's a very fair assessment, and many people can't. And those are the people that maybe this is the time to get out. If you have like big companies that have 1,000 units across different jurisdictions, not just Washington, but can spread it across other states, they're able to absorb it, because if Washington's not doing well, they can raise rent in Indiana and make up the difference.
On-staff attorneys also make a difference too with those big companies. So not having to pay $10,000 per eviction.
No, they still pay it.
Yeah. Help make me feel good about something. Go on. All right.
They still pay it. They can absorb it easier.
Katie, thank you so much. Yeah. If you can, message me when you get a moment, just like all your contact info and website stuff, and not like maybe a digital business card or something like that, and I'll include it. But I'm really grateful that you were able to take some time out of your day, because it looks very hectic with all those rules you have to follow.
Thank you so much. I appreciate the time.